format edit at this point.
Yeah, okay.
We've seen the underlying.
Well, I'll let you go ahead then. It looks like you've highlighted changes.
Yeah.
If there's anything you want to point out before we get to the changes, that's fine.
Okay, I'll just walk through changes. Well, actually, I'll just do a broader. Findings have not changed at all since Bill is introduced. Still the same, still relatively accurate. And I said relatively accurate because one of the things that Representative Rice sent this morning was about regulating not just neonicotinoid treated seeds, but insecticide, all insecticide treated seeds. And I don't know if you want to incorporate anything about that into the findings. Then you'll see the definitions. Nothing has changed here except when there's an environmental emergency. Page 6, line 2. The bill is introduced, had the Secretary of Natural Resources being the one who was determining whether it existed or not. And you change that to the Secretary of Agriculture. The next change is very similar. It's in the approval to use a neonicotinoid treated seed after the prohibition goes into effect. There's the authority for a written exemption. Previously, it had been the Secretary of Natural Resources consulting with the Secretary of Agriculture, and now it's the other way around. Moving on from there.
Question.
Is there sort of statutory precedence for consultation with, or is there a formalized sort of interagency agreement?
No, there's consultation throughout statute. A lot of the times it's ag consulting A&R on wetlands, on water, on a lot of things.
But there's sort of an agreement, like how far that goes. It's not just like we call you and your phone was busy.
Consultation is just, there's nothing specific in statute as to like what effort you need to make. There are a couple of provisions where the Agency of Ag can basically stop something from happening. But it's relatively rare. Page 7, in the written exemption order, when it's issued by the Secretary of Ag, they can specify the types of neonicotinoid treated article seeds to which the order applies, and then have additional conditions, including the order's geographic scope. This morning was requested to say which may include specific farms, fields, or properties. And then on page 7, again, in that written exemption order, line 13, there was language including, it had basically said, including that the exemption order will not cause undue harm. And you had discussed how that was going to be a very difficult standard to overcome as it related to pollinator populations. So it's including whether the exemption order will cause undue harm. Moving on to section 4. Actually, we're not on section 4 yet. Page 8, it's replacing Secretary of Natural Resources with Secretary of Ag for establishment of restrictions. And then when there is an exemption, on page 8, the Secretary of Ag submits that to the General Assembly. And again, when there is an exemption, page 8, line 10, the exemption may be rescinded. And you're just switching the Secretary of Natural Resources with the Secretary of Agriculture there. And then moving on to sec 4, so the prohibited uses of neonicotinoid pesticides. Yesterday, you had seen language about prohibited application to crops between tassel and harvest. And there was a recommendation this morning that Rep. Rice sent me to replace that with the outdoor application of neonicotinoid pesticides to soybeans or any crop in the cereal grains crop group. I think the recommendation this morning wanted the draft to add it to section subdivision 3, but it wasn't working. So it's a little duplicative. It's prohibitions on application to 2 separate types of crops. You could have done it differently, but I think this is a little bit clearer.
And this is just getting at the problem that Representative Graham brought up of, if we're going to the tropical bans, not prohibiting the farmer from simply planting untreated seeds and applying the annex themselves.
So moving on, next change is again flipping Secretary of Natural Resources for Secretary of Agriculture in the issuance of the written exemption. And then in that written exemption on line 19, the ability for the authority of the geographic scope to include specific farms, fields, or properties. Then again, replacing, including that will cause undue harm with weather. And then replacing Secretary of Natural Resources with Secretary of Agriculture with other restrictions. And then again, the replacement of ag with natural resources on the report for an exemption from the prohibition of use on neonicotinoid pesticides. And then again, switching or rescinding that exemption. Then, as I think we discussed at the last time I was here, since you're prohibiting multiple applications, multiple likely types with the, you want to kind of qualify this requirement that the Agency of Ag register neonicotinoid pesticides as restricted use. So it's unless otherwise prohibited, the Secretary shall register as a restricted use pesticide any neonic labeled as for outdoor use acceptable.
Mike, if a waiver is granted, is it up to, I guess, a conversation between the Agency of Ag and the farmer as to what their response could be, whether it's to use a treated seed or a foliar spray or some other IPM type solution?
Well, I think, remember, it's for an agricultural emergency or an environmental emergency, you're going to get that exemption. Either there are 2 different categories, right? If you want to use treated seed, you got to go seek the exemption under the treated seed section. If you want to do general application, you have to get it under the general application section. If you want to use both, you're going to have to do 2 different applications or some sort of merged application, which the agency sometimes does. So, I mean, it's going to be a discussion. It's going to be about the past. It's going to be about the exigent need, environmental, agricultural. It'll be fact specific.
Is there a timeline too? So if this year's crop was destroyed by corn maggot, could I say next year's crop I want to be able to use a treated seed?
Well, that's part of the exemption. It has to set the duration. So, okay. I think you are on to the kind of weird parts. And this is based on the input this morning to add to the existing requirement that the Agency of Ag adopt by rule BMPs for use in the state. And right now it's a BMP for use in the state of neonicotinoid treated seed. But there was concern or interest, I should say, in having BMPs when there's that written exemption order, because they're still going to be using them. So why not have the BMPs in those instances? And then there was also concern about those that when you're just going to authorize the use of neonicotinoid pesticides and it's not a treated article. So that's what subdivisions C1A through C do. It's BMPs for neonic treated article seeds prior to January 1, 2029, when they're prohibited. BMPs for the treated seeds when the secretary issues a written exemption order. BMPs when the secretary issues a written exemption order for just uses of neonic pesticides. You'll note that there isn't BMPs for their use prior to January 1, 20, or actually 26 of it. But that's up to you. Honestly, my thought process there is that they weren't going to get to rulemaking by the time that the prohibition kicked in. And so I just left that out.
Maybe we should look at those dates and then we can come back to this
Okay.
and see what makes sense.
And then the input from this morning about insecticide treated article seeds other than a neonicotinoid treated article seed. So my concern here is insecticide is not defined in statute. I know where I can get a definition. It's from the FIFRA rules, but I didn't want to just put it in without a little bit of consultation with you.
So we have asked for BMPs for non-neonicotinoid treated seeds.
You've asked for,
So I don't mean here, I mean, in the past, we have received from the AIB a report last year, a report on that hypothetically could have been BMPs for non-neonicotinoid treated seeds, as in seeds that are treated but not with neonicotinoids.
right. So like fungicides and things of that kind. Right, and you were supposed to get that report. That was the interim step between, you're supposed to get the rules, a copy of the rules next Friday.
Mhm.
I doubt you will. And it's only supposed to be a draft, because the whole concept is you get to see a draft of what the rules were going to be. And if you wanted to regulate them or enact them away, legislate them away, you could.
Mhm.
And otherwise, the agency could go to APA rulemaking. But yeah, you've had BMPs proposed
So I guess my question was just, what are we doing differently here than?
rulemaking. And that's one large part of it, because the underlying language from 2022 required it to be done by rule. And then well, insecticide is very limited. Insecticide doesn't include a fungicide. So that's one of the things I wanted to talk about. But pesticide does.
So I think Mike's question was, are we not already asking for a broader response from the board of some sort? That response, I think I heard you say, Mike, is yes, but it's not rules.
Right. So you asked for a report
Yeah.
from the AIB and what they would recommend, which has no binding effect. It's not even advisory, frankly, because it hasn't been adopted in any form by the agency. if you wanted it to be binding, and it's a little, non-intuitive. You have best management practices that are binding. But you do that in in several other programs. But I think the first three are intuitive, what they're going to be before January 1, what they're going to be when there's an exemption order for treated articles, what they're going to be when there's an exemption order for just general neonic use. But what they're going to be for other treated article seeds, I mean, are we talking about like tomatoes, like in your backyard?
Right, yeah, no, I think what we're trying to get at is diamide treated corn.
Okay, then I think you should probably say other insecticides, and I can add a definition of insecticides. I would just say insecticides and define it, and then at the end say including diamides.
Representative Graham has a comment or question here.
Well, we're changing this bill now to be all of insecticides.
No, I think the purpose of adding D there was to ask for the generation of BMPs around the use of other non-neonicotinoid treated seeds. So because of the concern that was expressed yesterday around the table about the just sort of like widespread just switch to diamides, and so and diamides not having any kind of BMPs for their use. I mean, John, is that?
Yeah. So why not just use pesticides there?
You could use diamides there or insecticides, or if you're going to say insecticide, it's going to be broader than diamides. And that's fine. I do include language in here or rulemaking about treated article seeds containing or coated with diamides. And so this is very specific to just diamides. Because
Jumped ahead there when I was just temporarily distracted. Like,
Right.
Where are we now?
So this is amending the 2022 Act, which required the BMPs for neonicotinoid treated article seed. And this is the timeline for it. And the input I received this morning said you should put it in a date when the agency would be required to go to rulemaking, including when it would be required to go to rulemaking for treated article seeds with diamides. And so that's what this language on page 15 does, 7 through 10. It's not the broad insecticide treated article seeds. It's just diamide treated seeds. Because that's what I got in the input this morning. It was at least my takeaway.
If we expand that,
Okay,
So is the concern,
It's not a ban. It's just best management practices for their use. It's not like the ban on the neonic treated seeds or the neonic pesticides in those specified applications. It's just when you're going to use diamide treated seed, this is how you should use it. Don't do it during bloom. Don't do it. Put, a 3-foot buffer, things like that.
I understand what you're doing.
so the, I think this conversation started because originally the bill as drafted said if the neonics are banned, we don't need to have that. We don't need to have BMPs for them, right? If they're banned, then there's no need to have that
Right.
practices. And then we recognize that, well, they're not going to be banned for 5 years. So in fact, we should have good practices available to everybody to use. And even if they are banned after 5 years, there may be exceptions. So we want to still have BMPs available, and they may be the same practices, but maybe somebody figures out new practices, I suppose, after that. And then there's the non-treated seed piece. There's just the foliar application, we want to have BMPs. And then the last piece was while they're thinking about BMPs, do we want to have them thinking about how to handle other seeds, treated seeds specifically? And I'll just add, and I'm just going to add that the Ag Innovation Board was charged with coming up with not rules, but a report on those treated seeds, and that's already come out. So, okay. Just, I want to be sure that I'm understanding correctly.
Yeah, I think it was an excellent summary.
And just so with the BMPs, who, it's the AIB that makes the BMPs?
No, the directive is for the Secretary of Ag.
Okay,
It's, in consultation with.
Right.
yeah, so that's still the same.
Got it.
So are there existing BMPs then? So in the case where, say, I'm the farmer, I'm not using treated seeds anymore, so I'm going to a synthetic erythroid or a organophosphate. Are there BMPs for those?
Well, I hope you're not using an organophosphate, but there are some BMPs for organic farmers and how they need to cultivate their crops and the buffers that they need to create if they're going to be, their crops are bordering conventional crops. But there are not BMPs, to my knowledge, just about the conventional, beyond what's in your pesticide permit. If you're using a restricted use pesticide, I don't know of any other conditions on their use. And the label always has conditions on its use.
Diamides are not a restricted use.
No, if it's treated, it's a treated seed. Remember, it's not even a
I
pesticide.
see. Yeah, so if you were to use a diamide,
If
if
you,
you were to use, if a farmer was to use it, it would be, it's a a restricted pesticide, but if it's a coating, a seed coating, then it's not
Right.
because it's treated there.
Right.
Yeah.
you got it.
Yeah.
So just to go back for a moment to the March 1st rules that are supposed to be issued for neonic treated seeds, and what that might conceivably look like. So in a world where there was no discussion taking place about banning them, no 706 here, could best management practices hypothetically go as far as saying that they can't be used? I mean, I suppose they could say they shouldn't be used, but do rules ever have that force, or given the legislation that required the rule?
I mean, it's a really, I'm just going to use some examples. So in statute, there are requirements for agriculture to have required agricultural practices. Like back in the day, they were called the accepted agricultural practices, but they were required, right? Some of them are required and some of them weren't. And right now you have the accepted management practices for forestry and accepted, right? And the statute says that they're voluntary, except they're not voluntary if you're in current use. So there's you when you start rulemaking around practices, it can get a little gray. But here, I think you probably have the opportunity for both. you can say, hey, best management practices applying neonicotinoid pesticide, don't apply it when like orchard crops are in bloom, right? Don't apply it then. It's a best practice to have a certain kind of seed, filter or something like that, seed box, or, those are, you could have mandates, but then you could have best practices. I think that's partly kind of what was in the AIB report. And before that, the Pollinator Protection Committee report. There were things that should have been mandatory, buffers from application, not applying during bloom, something to control dust. And then there are things that were more kind of advisory or instructive.
So, and I think you alluded earlier to, there's, when you talk about best management practices, and then the Canadian rules, it doesn't exactly line up with the way we think about those, the meanings of those words, but rules could include requirements. I mean, obviously, rules might mean requirements, so it could be, you can't use them under these circumstances.
Yeah. And I mean, the old accepted agricultural practices were a great example of that. They would have these mandates, you can't do this, you can't do this, and then like, you shouldn't do this. You shouldn't compost your animals within 2 feet of the border of your property. You would think that would be intuitive, and it wasn't a mandate, but they're like, don't do that, but we're not going to tell you can't do it. And then they got revised and it's like, no, you got to move your composted animals, I can't remember how far it was from bone. That kind of thing has happened. There's historical precedent for it.
All right. Other thoughts on this? I think maybe we want to just, let's see what else is in here and then we can.
Okay, so one of the other things in here, besides those 4, what the BMPs are going to address, is when the AIB, when the secretary is developing the rules with the AIB, they're supposed to address certain things like threshold levels of pest pressure. And if you're going to be talking about, remember, you now have BMPs for just general pesticide use and now for insecticide treated article seed. I figured if they're going to set those BMPs for those, then they should address these issues when they address when they adopt the BMPs for insecticide treated seeds or neonicotinoid pesticides. Am I making myself clear? I've been like going since like 9 in the morning. Like sometimes I'm not sure what's coming out of my mouth.
I would say keep going.
Okay. And then whether or not the availability of non-treated article seeds or that are not insecticide treated article seeds, economic impact from crop loss as compared to crop yield when, neonic treated seeds are used, insecticide treated seeds are used, neonic pesticides are used, relative toxicity, like all of those things that the agency is supposed to address in the rule when they do BMPs for neonic treated seeds are going to address them for insecticide treated seeds and the use of neonicotinoid pesticides generally. But in one of the comments from this morning is that they should also address the effects of insecticide treated article seeds on wild pollinators, managed pollinators, and other beneficial insects, and then also look at the effect of those insecticide treated article seeds on soil health and farms that don't use insecticide treated article seeds, including organic farms. Although organic farms, even organic has a little bit of treatment on some of their seeds. So
Kind of treatment.
I can't remember exactly what it is, but there are some allowed treatments. So and then moving on from there, this is the implementation that we already discussed. This is when they need to start. And when they need to adopt by. So on or before July 1, 2025, they shall establish those BMPs for treated article seeds containing diamides. And you can build in whatever schedule you want for those other BMPs, when they start, when they are supposed to finish, et cetera. But I want to note that the BMPs that are due March 1st has this provision on page 15, line 11. Ag shall not file the final proposal of the rules required, those BMPs for treated article seeds, until at least 90 days from submission of those proposed rules to the General Assembly. So if they don't deliver on March 1st, that 90 days keeps getting pushed back and back and back. So, and I think I've said this before, sometimes agencies just ignore you. And sometimes for decades. There's not a lot to do that you can do in those instances.
That's nicely. All right, so we're at the end here, and it's 2029 is the effective date for treated seeds. That January 1st, 2029 date is consistent with the New York State.
That's, yeah.
Station. Okay.
Mhm.
All right. John.
Just a couple questions on going forward, potential uses. One, say Chinese longhorn beetle attacks our maple trees, agricultural crop. Does that fall then into an environmental emergency or potential economic farm hardship?
I think that would probably be both, and I think it I know, or I think you know, that there's a disagreement between the Department of Forests and Parks and the Agency of Ag about who controls and regulates maple.
Christmas tree farms, are they considered farming?
They are farms, yes, but other tree farms are not. So it's going to depend really honestly on what application they're going to want to use. If it's me, I would probably seek a written exemption for general use of neonicotinoid pesticides, and I'd probably seek it as an environmental emergency because of the vast damage that longhorn beetle can do, not just to agricultural crops, but to the forest in general.
The other small question was on allowed uses now, like orchards, are there BMPs for those uses? Like an IPM type
Are there BMPs for what uses?
allowed uses of neonics? Like we're allowing still orchards to use it as long as it's right, not during bloom.
So that's what you're requiring. You're requiring the new rule provision would be BMPs for general use of neonicotinoid pesticides.
Okay, so it doesn't matter whether you're getting a waiver or whether you're using it legally right now or going forward, right? Each of those would get BMPs.
Well, those BMPs don't exist now,
Right,
but you're requiring them as part of the rulemaking.
Those are the three different kits that we're requiring BMPs for use before the ban on treated seeds goes into
Right,
effect
yeah.
in 2029. BMPs for use under a waiver after the ban goes into
Right.
effect, and then BMPs on the
General
use
use.
of general use,
Allowed
non-treated
general
seeds, but yeah, foliage, for instance.
yeah, okay.
I should probably, because right now it says neonicotinoid when issued under an exemption order, so it should when allowed or when it's, because there's going to be situations when it's just going to be allowed.
Yeah.
Yeah. So. For example, orchards. Can be
Yeah.
a-
Yeah.
One just language question, Mike, so we won't run into any language difficulties on that whole thing. Henry was mentioning about treated seeds. Can't have pesticides, or it's not considered a pesticide, so it's this weird sort of.
You already have language in statute about that.
That having a pesticide on a treated seed, it's not considered a pesticide.
That's actually federal law. There's an exemption that says any treated article is not a pesticide and is only regulated when the pesticide is applied to the article. And so it's it's a little bit of an artificial construct because it's called a treated article because the pesticide is applied to protect the article and not to serve any pest killing or pest distraction benefit. So an ear tag for your livestock that has insecticidal properties to keep away flies. So you're not protecting, it's not the pesticide's not in the ear tag to protect the tag itself. It's in the ear tag to repel insects, to repel pests. That's a pesticide. You got to register that. But when you apply that pesticide to your sneakers in order to kill fungus or anything else that causes odor in your sneakers, that's to protect your sneaker. And that's a treated article, and that's not considered a pesticide.
That was maybe day one, when we first came in. When we were looking at the bill, like we told us about the sneakers.
My favorite example is underwear, but people get a little bit bent about that. And I'm like, your underwear has a pesticide in it, and they're like, what?
Yeah. Okay, I'm gonna suggest that maybe we let Mike go and catch his breath. Not be thinking about drafting for a little bit. I want to, before we all leave for the day, we can take a break here to just stretch for a minute. But come back and I want to try and we're not going to vote on anything this afternoon, but I want to try and